Morning, Jennifer.
Hey, Derek. We've got people in the waiting room.
Yes, I think I'm going to admit them in just a moment. Just making sure my screens are all set up correctly here.
Okay.
Okay, I think we can admit people.
Okay, I will get them in.
Good morning.
And people who are not other.
Turn off my noisy air conditioning. And we're going to go ahead and give people until 10:35 to let people join in. You know, sometimes people are coming from back-to-back meetings, so we try to give a little bit of a 5-minute cushion there for people. Morning, Tabitha. Morning, everybody. Welcome.
Morning.
All right, we're going to give it a few more minutes as people join in. I'm going to put our agenda up here. We'll go ahead and get started at about 10:35. Is everybody able to see my screen and hear me okay? All right. If I forget to unmute or something, feel free to jump in. All right, we'll give it just a couple more minutes for people to join in, and then we'll go ahead and get started. All right, let's go ahead and get started. We might have a few people join us as we're doing introductions. My name is Derek Patterson, and I am the liaison to the County Vital Records offices for the Center for Health Statistics, and I will be facilitating today's meeting as well as our next meeting, which will be next week at the same time. This is our second of 3 Rural Advisory Committee meetings for Senate Bill 163. And just to sort of set the stage, Senate Bill 163 was passed in the 2025 legislative session, and it makes changes to how parentage is established for children that are born in Oregon. Some of the impacts of that have already been implemented by the Center for Health Statistics, things that became operational on January 1st of 2026. But most of the changes in the bill are things that will become operational for us January 1st of 2027. So the work that we're doing today is related to that. As a result of it, we're needing to create several new rules as well as amend some of our existing rules. We're also working on electronic system changes and some changes to our forms, but we won't be looking at those things today. That will be handled separately. We are doing a work group related to the forms and updating them and creating new forms for these new processes. So if that's something that you're interested in participating in, we will put an email in the chat where you can reach out to us if you're interested in providing feedback on those forms. That would be appreciated. But we're looking forward to getting your input today on the next set of rules that we're going to look at today. And that is related to denial of parentage, and a rule related to rescission of acknowledgement or denial of parentage. And then our last rule is registration of births under a gestational surrogacy agreement. So this is a different set of rules than we looked at last meeting, and then we'll look at 3 more rules in our final meeting next week. Let's take a look at the agenda here. We're going to go over meeting procedures and some reminders around that and do introductions. And then most of our time today we'll spend collecting feedback from RAC members about this set of these 3 rules. And then at the end we'll talk about some next steps and be done by noon. All right. Let's do introductions. We can do similar to last time. We want to do introductions just so everybody knows who's in the room and who's being represented. I appreciate you providing feedback on your organization's participation last week. I've streamlined our list a little bit here. So what we can do is I'll just start at the top. I'll just read each name for each RAC member if you're present. Feel free to come off mute or put something in the chat and introduce yourself. Let us know which organization you're with or what your interest is in this work. And we'll start with Jennifer Dees. Looks like not present. Robin Pope.
Hi, I'm a private attorney, longtime family formation attorney, served on the work group with Lane and others to write Senate Bill 163 and went down and lobbied for it. And I'm very interested in making sure that it gets implemented well.
Thank you, Robin. Lane Shetterly.
Yeah, thanks. I'm a retired lawyer who did not practice in this area of the law, so I don't pretend to be a subject matter expert by any means. But I did chair the work group that put together Senate Bill 163, and I did that in my capacity as a commissioner from Oregon on the Uniform Law Commission, from which the Uniform Parentage Act came. Glad to be here.
Thank you. Beth Wolfsong.
Hi, everybody. I'm Beth. I'm a attorney in private practice here in Oregon, and I work in this particular practice area. We deal with birth certificates and birth records quite a bit, so hoping to be able to help out or lend a hand or learn more about the process.
Thank you. Jen Wolfsong.
Hi, everyone. Ditto what Beth said.
Thank you. Ming Wong. Paula Amato. Maura Roach. Tabitha Coe.
Good morning, everyone. I am Tabitha. I'm an attorney working in this area in Oregon and in Washington. I was able also to serve on the SB 163 work group and contribute there a little bit. I'm really excited to learn and offer my perspective here. I am a board member for the Academy of Adoption and Assisted Reproduction Lawyers that is a national group with a lot of interest in these matters and a lot of expertise. I also was able to participate in the Washington implementation of a similar statute up there. And so I'm happy to look at things from that perspective as well.
Thank you. Sophia Hirons. Allison Kassler. Anita Rojas. Julie Cornelkin. Kara Stecker. Richard Vaughn. I think you might still be on mute.
I did the video, forgot the microphone. Good morning, everyone. Rich Vaughn. I'm the incoming chair of the ABA Family Law section. In the ABA capacity, I was an observer to the Uniform Parentage Act Committee prior to the 2017 enactment. I'm so happy to be an observer here as well.
Thank you. Beth Allen. Brent Leonhard. Amy Down Mall.
Good morning, Amy Down Mall. I represent the Hospital Association of Oregon.
Thank you. And then I see Jennifer Diaz, you've joined us. So would you like to introduce yourself?
Hi, good morning. My apologies for my late arrival. I'm Jenny Diaz. I'm the nurse manager for the mother baby unit at Providence, Portland.
Excellent.
Thank you.
Thank you. All right, let's go ahead and introduce our Center for Health Statistics subject matter experts and support staff. Jennifer Woodward, would you like to introduce yourself?
Sure. Thank you. Good morning, everybody. Jennifer Woodward. I am the state registrar, manage the Center for Health Statistics, and I'm a subject matter expert for this RAC. Thank you for being here.
Thank you. Danny Hall.
Good morning. I'm Danny Hall. I am the Center for Health Statistics Partner Services Operations Support Analyst. I'll just be backup support today.
Thank you. Let's see. Not with Center for Health Statistics, but Erin Williams, would you like to introduce yourself?
Yes, thank you. Hi, Erin Williams. I'm one of the Assistant Attorney Generals that advises the Oregon Health Authority. Thanks for being here.
Thank you, Erin. Ian Robbins.
Yes, hello. My name is Ian Robbins, and I serve as a business analyst for CHS, and I'm the project manager for our office for Senate Bill 163 implementation, with a focus on updates to our electronic registration system, or OVERS. Glad to be here.
Thank you. Joanna Collins.
Good morning. My name is Joanna Collins, and I am the amendments manager. And I am here as a subject matter expert, and I'm very happy to be here.
Thanks, Joanna. All right, I think we have gotten everybody. Is there anybody that hasn't had a chance to introduce themselves? I think we've got everybody. All right, thank you. Appreciate you all being here. I know you're all busy, and appreciate the feedback that you provide and taking time out to make these rules as good as they can be. As I said, most of our time is going to be spent collecting feedback from RAC members. A couple of important reminders around that. Excuse me. I'll be doing lots of talking today. A few reminders around that is this meeting is being recorded and it is public record. Any feedback that you provide about the rules is public record. It's also important to know that only Rule Advisory Committee members can provide feedback, but there is another place where anybody can provide feedback. There will be a public comment period, which takes place after all of the RAC meetings have concluded. So if you or if you know somebody that would like to provide a feedback that's not a RAC member, there is that opportunity later in the process. So we'd appreciate any feedback through that route as well. The way we'll collect feedback is I will read through each of the rules one section at a time. I'll try to pause for a little longer on each of those sections to give you time to think about questions and things. If you're a RAC member, please feel free to raise your hand using the Teams function to let us know, and then you can unmute and provide your feedback that way. If you're more comfortable, you can also put it in the chat. We'll try and keep an eye on the chat as well. And then we'll just go through it section by section. If you think of something later, we can always go back, especially if we have time at the end. So feel free to interrupt me. We want to make sure that we collect all of your feedback. We appreciate questions. There are questions we may not be able to answer, or we won't be focused on coming to a conclusion on some questions or making decisions. We really want to be focused on collecting any questions you have or feedback, because that will help us to know how the rules might need to be clarified or possibly changed. So we may not be able to answer every question, but we do have subject matter experts here that might be able to chime in and provide some context or some background information or answer some of those questions as we're going through. I will also read the notice of proposed rulemaking summary for each rule before we jump into it, just to set the stage and to provide an overview for what each rule does. There has also, it's important to know that there has been some level of review of these rules already. The Department of Justice, the Oregon Judicial Department, the Oregon Department of Human Services, and the Division of Child Support have all provided feedback on these rules already. And there have been some questions raised that we're going to look at today related to that. Any questions about the logistics before we jump into reviewing the actual rules? Okay. Let's go ahead and start then. The first rule that we're going to look at is OAR 333-011-0268, denial of parentage. Establishes the denial of parentage form as required by ORS 432.098-1A. Establishes the process and requirements for a presumed parent or alleged genetic parent to voluntarily deny parentage. This rule describes when and how the Center for Health Statistics will include or remove parents from a birth record pursuant to a denial of parentage, and when an amendment fee is required to amend a birth record. Oh. Got a Teams bar in the way. Okay. Section 1. For the purposes of this rule, parties is defined to A, include the parent who will give or who gave birth to the child, the alleged genetic parent as defined in ORS 109.002, presumed parent as defined in ORS 109.002, or intended parent as defined in ORS 432.005. B, exclude an intended parent as defined in ORS 432.005 when the child was conceived by assisted reproduction under a surrogacy agreement. What feedback or questions do you have about this section? Okay. Section 2, the denial of parentage form shall be available on the state registrar's website or upon request, and shall request or require information necessary to comply with state laws and regulations for denial of parentage, including but not limited to A, child's full name, B, child's date of birth or the expected date of birth, C, child's city or county of birth, D, the full name of the person who gave or will give birth to the child, E, the party denying parentage's full name, telephone number, email, address, F, a statement that the party denying parentage needs to read and understand the form, and that making willful and knowing false statements on this form can lead to criminal and civil penalties. G, signature lines for the party denying parentage, and H, space for notary information, signature, and notary stamp. What questions or feedback for this section? Okay. And if I move too fast, just let me know, or if there's something that you'd like to go back to, we can always do that. Section 3, a denial of parentage form can be completed, signed, and submitted to the Center for Health Statistics, CHS, before or after the birth of the child. A denial of parentage form is effective on the birth of the child or the filing of all required forms with the state registrar, whichever is later. Thank you, Lane. I see your comment, same comment as last week. This form on line 28 should be the form consistent with what appears on line 27. Thank you. Any other feedback on this section? Okay, section 4. The party denying parentage is responsible for accurately completing the denial of parentage form and mailing the original completed form to CHS at the address identified in the form. Okay. Section 5. A denial of parentage form must A, be fully completed with all required fields filled out, B, not contain any crossed out or altered information, C, include a complete and valid notary section with signature and date by a notarial officer, D, contain original signatures, E, match the child's full name if known, date of birth or expected date of birth, parent who gave birth's current name and name prior to any marriage, maiden name, in the birth report or birth record. For an expected date of birth to match a date of birth, the expected date of birth on the form must fall within 120 days of date of birth on the birth report or birth record. What questions or feedback do people have on this section? Yeah, Tabitha.
I have a general question. It does sometimes happen that the person who would be seeking to deny parentage doesn't know all of this information. So they may not know the maiden name of the woman giving birth, or they may not know her full legal name, her middle name, or whatnot. Is this rule suggesting that that person would not be able to successfully complete a denial of parentage form if they don't have that information?
Thank you. That's a great question to consider. Is there any background information or anything that any of our subject matter experts would like to add? Okay, we will.
Yep.
Oh, go ahead, Jennifer.
Sorry.
Thanks, Jennifer.
Yeah, I think, again, we have to be able to find the birth record to match it with. So, again, we have the match the child's full name if known, the date of birth, expected date of birth. And there is some indication, yeah, so I think, we'll need to consider that, but that's good information. I didn't know, Erin, if you wanted to chime in on this or not, but the goal was we have to be able to match it to the birth record. We have to find the birth record.
This is Erin. I think the idea is also like we don't want any, like I'm Erin Williams and I know there's other Erin Williamses out there, right? And probably none giving birth at the same time as maybe me, but to make sure we don't have any like confused, like potential issues with duplicate names or anything like that. I think it would be helpful to hear from the RAC of like, because we don't have your subject matter expertise on like what would people know, and if there is maybe more common information that people will know, that the agency could consider in deciding like what is the minimum information necessary in order to match the records. I think that would be useful input.
I think in a lot of cases, people do have all that information, right? But I definitely see people who are creating babies together that are lacking a lot of information about one another. I guess I was thinking of the way that we, for example, would search for a putative father for paternity. We provide sort of all the information we have, but we don't necessarily have all of it. And it was just that the rule, the way it reads to me, that person would not be able to, it's required that he provide it. So I guess I would suggest maybe having that name prior to any marriage, maiden name, again, if known. But I see your point that could create confusion. So it may not be soluble, but that's sort of an issue that I see.
Thank you for bringing that up so we can take that into account. I appreciate it. Robin Pope.
Oh, so ditto what Tabitha said. And then in my many years of doing adoption work and dealing with the putative fathers and those issues, to say match, and then we're going to run into this on the registration of births under a gestational surrogacy agreement also, with the expectation that the match will be exact. And that's probably, and I think Tabitha and Beth and Jen will agree with me, that's probably impossible in many cases. People won't know someone's maiden name. They won't even know if they were married before or currently married. So if there's some way to put in like substantially, or as Tabitha suggested, if known or reasonably available information. But there are times when people have maybe a first name and that's it. So the child's name and the date of birth is probably the better thing to rely on. You're going to have more luck with that than you are necessarily getting an exact match for the name of either the person denying parentage or the person who gave birth.
Thank you. Tabitha.
Sorry, I just wanted to share that in practice how it works now with Oregon and all of your entities is really helpful and great, and people sort of work with what everybody has. I'm thinking of when we're matching up an adoption report, right? If somebody had whatever, one piece of information that wasn't complete, we're able to provide the context and still get a lot of support and help. So we're really happy with the way things work in Oregon now. I just didn't want this to make it somehow rigid in a way that this path was not available. That's all.
Thank you. Any other feedback on section 5? I see your hand is up. Tabitha, did you have something additional, or is it just from the last question? Okay. Perfect. Okay, let's move on to section 6 then. Appreciate all the feedback. Section 6, the state registrar may require additional information from the parties to match the denial of parentage form to the birth report or birth record. Any feedback on this section? Okay, section 7, staff at the healthcare facility shall offer the denial of parentage form and witnessed acknowledgement of parentage to the parties, A, if the parent who gave birth to the child indicates on the birth worksheet for parents that they are A, married or were married within 300 days of the birth of the child, and B, the presumed parent is not the alleged genetic parent of the child. B, as otherwise directed by the state registrar. What feedback or questions are there about this section? Yeah, Lane.
Yeah, this section and section 8 refer to witnessed, in section 7, you say witnessed acknowledgement. I assume that's witnessed voluntary acknowledgement of parentage. And in 8, it does refer to witnessed voluntary acknowledgement of parentage. My only question is, we looked at rules last week, one for witnessed VAPs and one for notarized VAPs. Do these sections not pertain to notarized VAPs? They only refer to witnessed.
Mm-hmm. Would any of our subject matter experts like to chime in on that?
Yes, it's this section is for witnessed. The notarized VAP is further on in the rule, and we need to make sure that we say notarized. So we'll when we get there, but this is specifically for the witnessed VAP that happens at the hospitals.
Okay, so notary is coming up in this rule?
Yes.
Okay, okay, all right, but it apparently doesn't say notarized where it comes up later.
Yeah,
we'll look for.
Yeah, I think it's in section 11. But yep.
Perfect. Thank you.
Oh, okay. All right. All right. Thanks. But I think in section 7, we still want to say the full title of the voluntary acknowledgement of parentage, right? This refers to witnessed acknowledgement.
Yes.
Yeah. Thanks.
Mm-hmm. Yep. All right. Let's see. Jenny.
I just want to clarify if this is new, this part that we're advising, because I would say in practice, this is not something that we currently practice doing, is offering this denial of parentage form. So I just want to find out, is that something that's new, or is it just something that I'm not aware of?
It's new. It's new language. The whole denial process is a whole new process in law.
Okay, thank you.
Thank you. And Jen.
I was just going to note there's just a slight discrepancy when it said in number 5, it says a denial of parentage form must include a complete and valid notary section with signature and date by a notarial officer. So is the hospital staff are just going to witness, right? Not notarize? So there'll be 2 different forms?
No, they just provide the form. They're not responsible for filling it out because it has to be notarized.
Oh, it does.
So,
Okay.
yep,
Okay.
under the
Got it.
law, under the law, it's a notarized form, not a
Okay.
witnessed form.
Got it. Okay. So they'll witness the signature. No, well, what are they witnessing then?
They would be witnessing the voluntary acknowledgement of paternity and then just handing the individuals the denial form. And if they have notaries available at the facility, they could complete it then, but they would just be handing them the form.
Okay. Thank you.
Thank you. Any other questions or feedback on this section? Okay, section 8. 8A, if a witnessed voluntary acknowledgement of parentage form indicates that a denial of parentage form will be submitted, and the parent who gave birth identifies the presumed parent at the time of birth on the birth worksheet for parents, the healthcare facility staff shall enter the presumed parent on the birth report. If the presumed parent is not identified on the birth worksheet for parents, no second parent will be listed on the birth report. B, if the healthcare facility receives a completed denial of parentage form, it shall be submitted to CHS as outlined in OAR 333-011-0266. Any questions or feedback on that section? Okay. Section 9. When a birth report identifies a presumed parent and indicates that a witnessed voluntary parentage form and denial of parentage form will be submitted to CHS, A, the state registrar shall only register the birth to include the parent listed on the witnessed voluntary acknowledgement of parentage after receiving and accepting the denial of parentage and corresponding witnessed voluntary acknowledgement of parentage. B, the state registrar shall register the birth with the presumed parent listed as the second parent if the denial of parentage form and a witnessed voluntary acknowledgement of parentage form are not received and accepted by the state registrar within 45 days from the date of birth. Any feedback on this section? Lane.
Yep, just another minor grammatical thing, but on lines 39 and 40, I think that should read witnessed voluntary acknowledgement of parentage form.
Perfect. Thank you. Appreciate it.
Yeah.
Any other feedback on this section?
I have a question.
Yeah, go ahead.
Is the 45 days, is there leniency to that at all with legality? Because I do know that there are times when perhaps that other parent is not available to sign or be going to see a notary. Perhaps they're out of the country or incarcerated.
Thank you. Good question. Any of our subject matter experts want to offer any information on that?
Yeah, we 45 days, that was the time frame we picked. We're open to that. It is not written in law about the 45 days. That was what we had established in rule, just to with the idea of how long it might take for the forms to get to us. If the RAC recommends a different time frame, we could consider that.
Thank you. Would anybody like to offer anything further on that? Yeah, Tabitha.
I would just say my initial feeling is that the 45 days is probably appropriate because you're balancing getting a birth certificate that has at least the current state of affairs accurately reflected for who the child's parents are. And I think they could still deny parentage later and establish a voluntary acknowledgement. Is that right? But they would need to go through a different process. It's not the hospital's responsibility.
That's a good question. Is anybody able to clarify more on that, whether that would be the case?
Yes, that is the case, and that this is focusing on the witnessed voluntary acknowledgement of parentage form and the denial. So it's like the hope that the hospital would get the witnessed voluntary acknowledgement of paternity, parentage form, excuse me, to us, and then the denial would come because there is the option under the notarized version, because we could still receive a notarized voluntary acknowledgement of parentage form and the denial parentage form much later. And so there is that option, and also there's the other legal options as well.
Thank you. Robin. Oh, I think you're still on mute.
Following up on what Tabitha said, there might actually be an argument or discussion point for making it less than 45 days. Because a lot of people need birth certificates in order to put children on health insurance. And a lot of HR departments at bigger companies want that within 30 days of birth in order to do that. So I'm just throwing that out there. I don't do adoptions anymore. So I think Tabitha and Beth and Jen probably have a better handle on that. But my clients who do surrogacy, they want those birth certificates as fast as they can get them so they can get their babies on their health insurance. So, I mean, you could even think about 21 days or something like that.
Thank you. Any other feedback about that time period or anything related to that section? Tabitha.
I guess it's a question maybe for Jennifer Woodward. Would there be a birth certificate? Could the woman who gave birth still obtain, or the person who gave birth still obtain a birth certificate prior to the time that second voluntary acknowledgement is filed and the denial? So if the birth is going to be reported with the person who gave birth's name and then whatever presumed parent is there. Until that's changed by these subsequent forms, right? Or is it that there would be no birth certificate even available for 45 days?
Yeah, we would be registering it with the presumed parent if we don't get it within 45 days. So we have 45 days, we'll register with the presumed parent. And I believe we have the options to remove yes. So after that time, yes, the presumed parent and the would be able to get the birth certificate after 45 days. The second parent would be, yes.
Thank you. Any other discussion on this? Okay, section 10. If the state registrar receives an acceptable notarized voluntary acknowledgement of parentage and corresponding denial of parentage prior to the birth of the child, the state registrar shall A, hold the forms until matched with a birth report or record, B, add the parent listed on the notarized voluntary acknowledgement of parentage if not included in the birth record, and remove the parent denying parentage if included on the birth record. What feedback or questions are there about this section? Robin. Oh, you're still muted.
How long would it be held for? Would be one question. And then who determines what's acceptable? And
Thank
so
you.
in 10, in line 7.
Good questions. Is there anything our subject matter experts want to offer?
Yeah, it's based the idea of being an acceptable, reviewing it and based on the qualifications for it being completed, the denial of parentage form. So I see. So the acceptable voluntary, notarized voluntary acknowledgement of paternity form was covered what was required in our previous rule that we discussed last time, which outlines what needs to be completed on the form as would be considered acceptable. And also the denial of parentage related to what is required to be completed. And I think we talked about for the denial what items we may not need to include. So everything would need to match and meeting those requirements in the previous citation of the rule, that it be completed, not contain cross outs, include completed validly notarized section and original signatures and matches.
So do we need to somehow say that needs to comply with the applicable rules? Because to say just acceptable, it's like, who decides what's acceptable? People need to know how they make it acceptable, just with a quick reference backwards, I think.
Okay.
Otherwise, they'll be like, I don't know what's acceptable.
And answer your question about holding the forms. I believe that we would hold these until we got the matched with the birth report or birth record, assuming there is a birth that occurs, and so we would hold those until it is matched. And I think
what if, like we just discussed on just above, you can't match it because there's some missing name or something? Well, that could hold things up, couldn't it?
yes, it could. And so that's why I think we would change the information about what names we would have if we want to move back to potentially just the child's birth and date of birth. We could consider that as well. But what I'm hearing is we might want to have some language specifically related to how long we'll hold both of the forms.
Yeah, I think because they could sit there in perpetuity
Mm-hmm.
and then never get matched, and then nothing's going to happen with it. So it seems like there should be some limit, and then I guess some way to come back to it so people come in after the limit is reached.
Yes, and we have in section 14 and 15, I believe. Yep, we do in section 14 and 15 of this rule, there is information about how we would contact the individuals if we haven't gotten the forms.
Right, because it says that you won't amend. I'm just trying to look at those real quick. It just seems like it would be important to put some end date on it, and then a way to get around the end date if people come back in with the right information and the right forms.
And we do say in section 12 how long they would be held for matching until they would be matched for 6 months. And then part of it is the unmatched denial parentage forms. And then we had some questions from our last meeting about how long we should be keeping those forms before they're destroyed.
Right, right.
Perfect. Thank you. Lane.
Yeah, thanks. And again, reading this as a non-expert, but in section 10 says what happens if the registrar receives an acceptable notarized voluntary acknowledgement. Is there a corresponding provision of this rule that pertains to witnessed voluntary acknowledgements. I don't see it, at least not clearly. And so my question is, should this rule relate to both notarized and witnessed? Or do we need a separate? The rule generally just seems to be a little bit awkward in how it combines or refers in places sometimes to notarized and some places to witnessed, and it's not clear how the parallels are working here. And this is a place that is confusing in that respect.
Thank you. Any other feedback on this section?
Hi, this is Erin.
Yeah.
Lane, I can direct you to subsection 9, which addresses, it's like the witness version of 10. And I will not disagree with you that it is confusing. And a lot of that has to do, I think, with the idea that the processes for CHS when they get a witnessed is going to be different versus when they get a notarized. And that's why you're seeing that language going back and forth. But it's helpful to know, and I think we will think a little bit more about if there's ways to organize the rule so it's a little bit clearer.
Yeah, I appreciate that. Yeah, and I thought section 9 might be the corresponding, but for instance, 10 says if the registrar receives an acceptable or notarized, we're going to play with that language. But section 9 doesn't have that kind of reference. It just says when a witnessed voluntary form identifies a presumed parent. So they're not parallel. So I appreciate that, Erin. It seems like there could be some work to try and make these more clear in how they relate to both witnessed and notarized VAPs.
Yeah, I agree. Thank you, Lane.
Thank you all. It looks like we've got a question in the chat. Witnessed will only apply after the birth, correct? Because it will be at the hospital.
Yes, that is correct.
Okay, perfect. Thank you. Anything else on this section? Okay, section 11. When a birth report identifies a presumed parent as the second parent and does not indicate a witnessed voluntary acknowledgement of parentage shall be submitted, and no notarized voluntary acknowledgement of parentage and corresponding denial of parentage was received prior to the birth, the state registrar shall register the birth with the presumed parent as the second parent. A. To remove the presumed parent from the birth record added under Section 11 of this rule for no fee, CHS must receive via mail postmarked within 14 days of the birth of the child an acceptable denial of parentage form and a notarized voluntary acknowledgement of parentage form. B. To remove the presumed parent from the birth record added under Section 11 of this rule when a denial of parentage form and a notarized voluntary acknowledgement of parentage are mail, postmarked more than 14 days after of birth of the child, CHS must A. Receive and accept a notarized denial of parentage form and a notarized voluntary acknowledgement of parentage form, and B. Receive an amendment fee and Oregon State Vital Records amendment order form. Any questions or feedback on that section?
Just I assume that the garbled language in the opening paragraph to B will be corrected. We got some missing words and things.
Thank you. Robin.
Line 18 on number 11, it says, and does not indicate a witness VAP shall be submitted, should be will be submitted.
Thank you.
There is actually a difference there.
Any other feedback on this section?
We have that acceptable again on line 25.
Okay.
Just again, I think it will cause perhaps some questions, maybe not, but.
Thank you.
Yeah, I think if you could just say in compliance with, that really says what it needs to say.
Any other feedback on this? Okay, appreciate it. All right, number 12, denial of parentage forms received by CHS shall be held for matching with birth reports, birth records, and corresponding acknowledgement of parentage forms until matched or for 6 months after receipt, whichever is earlier. Unmatched denial of parentage forms will be stored for an indeterminate number of years and then destroyed. Feedback on this time period or anything related to this section? Robin.
The time period, I think it's a little bit of a dilemma because we don't want you to have to keep forms forever and ever. But then you also have, the minority of a child. So, I mean, should they be held for 18 years? Children are minors until the age of 18 in Oregon. Or should it just, we just arbitrarily pick a period of time, 7 years, 1 year, 2 years, whatever. I don't know.
Thank you. Jen.
I'm just a little confused. So it says, well, held until it's matched or 6 months after receipt, whichever is earlier. I'm not sure. Does that mean you're going to destroy it after that?
Thank you. Good question. Any of our subject matter experts?
Yeah, I think the a goal here was that we would be continuing to match, check regularly. So it's continuing to check, every week, just to because it's not an automatic match. Someone has to go in and look at the forms and see if we've got a match. So we continue to match or for 6 months after receipt, whichever's earlier. So we continue to check, and then after 6 months, we just stop, and then set them aside, and then the idea is how long do we keep them set aside until we can destroy the forms.
Thanks.
Thank you. Robin.
So Jennifer, I guess I'm curious, you say that people check regularly. Do you have an idea of like how many records are not matched, like under the current system? I suspect it may not be that much different going forward.
For voluntary acknowledgement, since we only have the voluntary acknowledgement of paternities, the notarized and witnessed ones, so far those usually get matched. Again, the issue here is now this is a whole new form and a process for us with the denials. So it's kind of making sure we have all the forms to do the match. But one of the questions that we examined doing the rule writing was, how often does this happen with our current acknowledgement of paternities? And usually after 6 months they are matched, but we really don't know what's going to happen with the denial since it's a new process for us.
And then how often, if at all, under the current system, so let's say it doesn't get matched, which sounds like it's unusual, small numbers, and then sometime down the road, whether it's a year, 5 years, 8 years, whatever, do people come back in and say, wait a minute, I want to get this matched up? Does that ever happen?
They usually are all matched within 6 months.
So they're like 100%?
Yep, I'm going to ask Joanna to chime in. I believe that when I did the connected with the team, it's that with the voluntary acknowledgement of paternities, yes, they're usually all matched by then.
That's pretty cool.
And I'm going to let Joanna confirm that. So Joanna, I'm going to let you chime in.
Yeah, no, you're spot on. Yeah, we don't have an issue beyond 6 months without them being unmatched.
So this storage thing, we hope, will not be a big issue. Is that correct? Does that sound
That is
right?
our hope.
That's our hope.
So then would it matter if we said it was 18 years, just in case, because of a minor child? Or is it better to just say, pick some arbitrary time and be done with it?
Well, the conversation we had last week about the because we did have similar language for the witnessed VAP and also the notarized VAP was about, I think we mentioned a couple of years, but we're totally open to this. That's why we have it here with a question mark on just getting some guidance on your suggestions for that.
Thank you. Tabitha.
Thank you. I think I had chimed in about a couple of years seeming reasonable when we were looking at the rule last week. Robin, I really respect your perspective and thinking about keeping them for the whole minority of the child. I guess there are a few inflection points that I see when people tend to come into us to clean up birth certificates. And Jen and Beth probably see this too, especially with same-sex couples or people who might not have been married at the time. And they are sort of solidifying that. And one inflection point, of course, is birth. Well, a second one is typically around 2 or 3 years old when they're sort of coming out of that baby phase and realizing that maybe they need to take care of this. A third point is when the child starts school around age 6, when we see people finding that, their then boyfriend who was listed on the birth certificate and was not the genetic parent and is not involved really shouldn't be the parent. So that's another point. And then, of course, there's adulthood, 18. So I guess I'm interested in Jen and Beth, your perspective from dealing with clients on this. I think actually 2 years is too short, but maybe it should be 6 years. What do people think?
Robin, I see you've got your hand up.
Right. Actually, so I'm going to chime back in with 18 because those were great points, Tabitha, because we also have when they go to get a driver's license, okay? And then when they go to apply for college and they apply for grants or scholarships or anything like that, they've got to have a good birth certificate, passports, all of those things. So I would vote for 18. I don't think it's going to be in a computer, right? I think so. It shouldn't take up much space.
Thank you. Anybody else like to provide input on that? Okay, any other comments or questions on section 12? All right, section 13. The state registrar shall establish a replacement for the record of live birth after amending a record of live birth under this rule. Jen.
I'm sorry, can I go back to 12 for a second?
Yeah.
I just took my head a minute to catch up.
Absolutely.
I am wondering so if you've got these denial of parentage forms that are unmatched, that means there's been no birth record that has been matched with that denial of parentage form?
Thank you. Any of our subject matter experts want to clarify?
It's focusing just on the form itself. So you're right. Yeah. So if we shall be held for matching with the birth record and corresponding voluntary acknowledgement. So if we probably have the birth, but we haven't gotten the corresponding acknowledgement of paternity forms. It's just the kind of the denial form that's come in, and we're matching and waiting. We have the birth, but we may not have the acknowledgement. with that. And I think we cover that, a lot of what we do in those cases in 14 and 15. But it also could be we may not have the birth record as well. So it's kind of both.
So if you don't have the birth record, what happened to it? Does it mean the baby was born somewhere else?
Most likely the baby
Okay.
born someplace else.
Got it.
Yeah.
Thank you. Any other questions or feedback on 12 or 13? Okay. Section 14, when the state registrar receives a voluntary acknowledgement of parentage form indicating another person is denying parentage and no denial of parentage has been received via mail postmarked within 14 days of the birth of the child, the parties on the voluntary acknowledgement form will be informed that the denial has not been received. The state registrar shall not amend the birth record or add the person acknowledging parentage to the birth record unless or until a denial of parentage is received, accepted, and matched to the birth record or birth report. Any feedback or questions about that section? Okay. Section 15, when the state registrar receives a denial of parentage form and no corresponding voluntary acknowledgement of parentage has been received via mail, postmarked within 14 days of birth of the child, the party on the denial of parentage form will be informed that the notarized voluntary acknowledgement of parentage has not been received. The state registrar shall not amend the birth record or remove the person denying parentage from the birth record unless or until an acknowledgement of parentage is received, accepted, and matched to the birth record or birth report. Any feedback about that section? All right. Section 16. If the state registrar is aware that parentage is being denied and a voluntary acknowledgement of parentage form indicating another person is denying parentage or a denial of parentage form has not been received within 14 days of the birth of the child, the parents listed on the birth report or record will be informed that appropriate forms have not been received. Any feedback on that section? Yeah, Lane.
Yeah, thanks, Derek. Just a question. You got the passive voice there in line 20. The parents listed in the report will be informed. I guess in statutory language, we like more the active voice. It is who's going to do it. I would suggest an amendment to that language.
Thank you. Any other feedback? Okay. Section 17. When processing a request under this rule, if the state registrar has cause to question the validity or adequacy of the documentation, the state registrar in the state registrar's discretion may request additional information or documentation or may refuse to register the live birth or amend a record of live birth. Anything for that section? Okay, so the next rule is regarding rescission of acknowledgement or denial of parentage. And I will read our summary from the Notice of Proposed Rulemaking. Rescission of acknowledgement or denial of parentage establishes the form and process used by individuals who wish to rescind or take back their agreement to an acknowledgement or denial of parentage. This rule describes when and how the Center for Health Statistics will include or remove parents from a birth record pursuant to a rescission, and when an amendment fee is required to amend a birth record. The rules outline the process for informing parties as required under ORS 432.098, Section 3. Okay. Section 1, for the purposes of this rule, parties is defined to A, include the parent who will give or who gave birth to the child, the alleged genetic parent as defined in ORS 109.002, presumed parent as defined in ORS 109.002, or intended parent as defined in ORS 432.005. B, exclude an intended parent when the child was conceived by assisted reproduction under a surrogacy agreement. Anything for that section? Okay, and thank you, Lane, for pointing out some passive voice. Anything else? Okay, Section 2, the rescission of acknowledgement or denial parentage form shall be available on the Center for Health Statistics website or upon request to CHS, and must request or require information necessary to comply with state laws and regulations for denial of parentage, including but not limited to A, information matching the acknowledgement or denial to be rescinded, including A, child's full name, B, child's date of birth or expected date of birth, C, child's city or county of birth, D, full name of the person who gave birth to the child, E, full name of the party rescinding acknowledgement or denial of parentage, B, rescinding party's telephone number, email, and address, C, a statement that the party rescinding acknowledgement or denial of parentage needs to read and understand the form, and that making willful and knowing false statements on this form can lead to criminal and civil penalties. D, signature lines for the party rescinding acknowledgement or denial of parentage, and E, space for notary information, signature, and notary stamp. Any feedback on this section?
I lost my hand raising thing for
Oh.
temporarily.
Oh, no,
Anyway,
that's
sorry.
okay. Go ahead.
So do we need to be clear to do what Lane recommended before, to be very clear about using the full term for the voluntary acknowledgement paternity or the denial of parentage forms? Do we need to do that? Is that necessary as we go along? It seems like you want to be consistent and make sure people know exactly what we're talking about.
Yeah, we can definitely take a look at that. Thank you. Anybody else? Or any other feedback?
I just have a quick, maybe a
Mhm.
silly question,
Yeah.
but when I say someone's full name, I guess I'm assuming that we have to at least have a first and a last name, but what if you don't have the middle name? Or I don't know if that really matters, what we consider a full name.
Mhm. Thank you. Anything else on this section? Okay. Section 3, a rescission form must be filed with the state registrar within the earlier of A, 60 days after the acknowledgement or denial becomes effective as described in ORS 432.098, or B, The date of the first hearing before the court in a proceeding related to the child, including a proceeding to establish a support order in which the party wishing to rescind the acknowledgement or denial is also a party. Any questions or feedback on that? Yeah, Tabitha.
Sorry, it's a practical question, but in a situation where someone is contemplating filing a rescission, but they're waiting, for example, on a DNA test to be completed, it seems like 60 days might be a little short. And I don't know if that was a number that we came up with for this rule, or whether it was in the statute. Yeah, go ahead.
It's in the statute.
Okay, then we're stuck with it.
Thank you. Lane?
Yeah, on line 40 there, a rescission form. Is that a rescission of voluntary acknowledgement or rescission of denial of parentage, or both?
Thank you.
It's both.
Okay. Just again, whether we should say that, maybe not. Maybe practitioners and everybody else understands the shorthand there, but it wasn't clear to me.
Thank you. Any other questions or feedback on this section? And I see your comment. I see a comment in the chat from Jen regarding a citation, and thank you for that. We will look at that citation, double check it. Thank you. Okay, section 4. The party rescinding acknowledgement or denial of parentage is responsible for accurately completing the rescission form and mailing the original completed form to CHS at the address identified in the form. Any questions or feedback? Okay, section 5, a rescission of acknowledgement or denial parentage form must A, be fully completed with all required fields filled out, B, not contain any crossed out or altered information, C, include a complete and valid notary section with signature and date by a notarial officer, D, contain original signatures, E, match the child's full name if known, date of birth or expected date of birth, the current name of the parent who gave birth, name and name prior to any marriage, maiden name, in the acknowledgement or denial to be rescinded. Questions or feedback do we have about this section? Robin. Oh, I'm not able to hear you.
Sorry, I always forget.
Oh, there we go. That's okay.
It's a question in general about containing original signatures. Is that like what we would call a wet signature, or some of us now use, our clients use online notaries? And are those technically original signatures? I don't know the answer to that.
Thank you. Any of our subject matter experts want to clarify?
This is wet ink signatures. I think one of the things that we're still working on is getting some legal guidance on, because currently we don't accept the voluntary acknowledgement, the notarized acknowledgement of paternities, or any documents with an electronic notary on for these forms, since they're the legal forms. So that would be something we would need to get clarification on, if we can accept the electronic notarizations. We have not gotten legal opinion on that yet.
Thank you. Lane?
Yeah, again, just a drafting thing. In 2E, it refers to, I just lost it. In 2E, it refers to space for notary information, signature, and notary stamp. in 3C, 5C, it says a complete and valid notary section with signature and date by a notarial officer. I don't know why they're not the same thing, and wherever that appears, I don't know why that should be different. And of course, different language always suggests that it means something different. So I would suggest that you try and harmonize wherever that language appears.
Thank you. Any other feedback on this section? Okay, section 6. The state registrar may require additional information from the parties to match the rescission form to the acknowledgement or denial form to be rescinded. Any input on that? Okay, section 7, if the state registrar has added the information from the acknowledgement or denial being rescinded into the child's birth record, the state registrar shall amend the existing birth record to remove any information added or changed due to the acknowledgement or denial of parentage from the birth record and any corresponding denial or acknowledgement of parentage, A, after receiving and accepting the rescission form, and B, receiving any required fees. Any questions or feedback on that? Robin.
Sorry. So it says to remove any information added or changed. I get that to remove anything you want to that was changed, but if you added information, then why are you removing it? And maybe that I'm just not reading this correctly. So you'll amend.
Yeah, if we've added the father, the second parent, the second parent in. So if we'd added the second parent, we would be removing the second parent because you're doing a rescission on a denial and or an acknowledgement. So the acknowledgement would have added in the second parent and the rescission would then remove that parent. And then so that is why we use the word added or changed.
Okay, so the information would have been added earlier, but now you're removing it.
Mm-hmm.
Okay.
And then any information that's changed with the denial and or the acknowledgement.
Changed makes sense to me. The added just doesn't work as well. But I understand. Thank you.
Thank you. Tabitha.
I know fewer words is better than more often, but I wonder if we could just include the word previously added or changed. So amend the existing birth record to remove any information previously added or changed due to the acknowledgement.
Thank you. Any other feedback on section 7? Okay. Section 8. A birth record amended under this rule shall A, revert to the parentage information included on the birth record prior to the acceptance of the acknowledgement or denial of parentage that is being rescinded, and B, not indicate that it has been amended. Any feedback on that section? Okay, section 9. Upon receipt of a rescission of acknowledgement of parentage, the state registrar shall notify the individual who assigned an associated denial, if any, of the rescission and that the denial may be invalid because the acknowledgement has been rescinded. Any feedback on that? All right, section 10. Upon receipt of a rescission of a denial of parentage, the state registrar shall notify the individual who signed an associated acknowledgement of parentage form, if any, of the rescission and that the acknowledgement may be invalid because the denial has been rescinded. Any feedback or questions on that section? Okay. Section 11, when processing a request under this rule, if the state registrar has cause to question the validity or adequacy of the documentation, the state registrar in the state registrar's discretion may request additional information or documentation or may refuse to register the live birth or amend a record of live birth. Any feedback or questions on that section? Robin.
I guess I'm just curious, and I thought about it previously because we have the same thing in the prior section, but it says that the state registrar may refuse to register the live birth or amend a record of live birth. So what happens? And maybe I'm wrong, but it seems like that's a fair amount of discretion. So if the state register has cause, and that is that reasonable cause? Is it good cause? Is it just any cause whatsoever? And Jennifer, I think that your office would do absolutely, it would only be for absolutely good, strong cause, but it is a rule. And I think we need to be clear, because if the live birth isn't going to get registered, what happens? Then there's no birth certificate. I don't know.
Yeah, thanks. Again, as you notice, we put this in all at the end of the rules, and I'll let Aaron chime in as well. But I think that some of the questions that we've had is that if we're having some concerns about fraud or any issues related to that, or we don't, it's fraudulent documentation or it's incomplete, that that I have a little bit of the discretion to say, no, we don't have the documentation that we need to do this. And we can refuse to register the live birth, and there would be no record of birth. And then one of the questions that Aaron and I had back and forth when preparing these is, then do we say you need to go to you need to go to court? And I'll let Aaron chime in as well, because we did talk about this language quite a bit. So
yeah, and so I would really appreciate knowing that, because I feel like, and then I understand why you haven't come to a conclusion yet, but it's like it's just kind of dropped here, and then now what happens? What does someone do? Like the person who gave birth can't get a birth certificate, and that could cause a lot of problems. And children, I've run into people who didn't have birth certificates, and when they're adults, it's a huge problem. So it seems like we need to address that and make sure there's a process, even if it's just to say, like you say, go to court, figure it out. And then I guess I would like there to be some kind of, what kind of cause do you have to do something that is actually fairly drastic, to not register the live birth? Thanks.
Thank you.
I'll just chime in. This that has caused to question the validity or adequacy is statutory language that we pulled from 432. And I think the comments about what does the process look like after that, that's something that we've also thought about, and not sure if it's something to put in rule or not. But that's all of that is really helpful input.
Thank you.
So out of curiosity, what would it take? So you've refused to register because you have cause to question, and that's very appropriate. So you have that cause, and then presumably people go and try to figure something out. What would it take for the state registrar to then say, now we will go ahead and register the live birth? What would you need in order to do that?
Well, I think it would be making sure, that we're going through and looking at the documentation that was provided, because we're focusing on the rescission forms here. So if, for example, we don't have a complete rescission form, or we've asked for the rescission form, or we don't have the denial or the acknowledgement forms that have been accepted, that would be the case. Again, this is, as you've noticed, this is standard language that we put across all of them. So I think we would be going back and continuing to ask for the documentation, and if we never got it, then we wouldn't be able to amend the record or register the record.
And that is actually a good reason for having some of the time limits that you've put in there, I think, throughout the rules. And maybe we need to go and look at those to make sure that if something hasn't happened within X number of days, whether it's 21 or 45 or whatever, that you would then have the authority to do what you need to do to register the live birth.
Thank you. Appreciate that. All right, we are out of time for today. I appreciate you all providing a lot of great feedback and questions. We didn't quite get to our third rule, but we do have some extra time in our next RAC meeting, so we will move that to our next RAC meeting and look at it during that meeting. Our next meeting will be next week at the same time, our final RAC meeting. I will put an email address in the chat for if you have any questions, or if you're interested in participating in that work group about revising forms or providing feedback about those draft forms, or actually if one of our support staff could stick that in the chat. Thank you so much. We appreciate you being here, and we hope to see you next week. Thanks, everybody.
Thank you all. Really appreciate it. Thank you so much.
Thanks.
Thanks. Bye.